So, Asha, is the Supreme Court going to reverse course and gut the Voting Rights Act?
It's complicated.
I'm Renato Mariotti. I'm a former federal prosecutor, a practicing lawyer, and a legal analyst.
And I'm Asha Rengappa. I teach national security law at Yale University. I'm a former FBI special agent, and I'm the author of the Freedom Academy Substack.
And I'm Rick Hasen. I'm a UCLA law professor and director of the Safeguarding Democracy Project. My most recent book is called A Real Right to Vote, published last year by Princeton University Press.
And we're here to help you understand topics that can't be boiled down into a soundbite or a skeet. Well, thank you so much, Rick, for joining us. You are such a special guest, probably the leading expert on election law, and really somebody that I think can help us all understand a very complicated area of the law.
Well, glad to be able to be with you and to give you more than a soundbite.
Yeah, there have been a number of times where I asked Renato, I'm like, should we try to get Rick on? Because there have been these various cases, big voting rights cases. But just in light of this last one, I was like, let's get him on and unpack all of this. But I'm wondering if before we get to the case that was argued last week in front of the Supreme Court and what it means and where it's going, can you just kind of lay out for us how we got to where we are now and, where this case that was just argued fits in with the longer arc of, how the Voting Rights Act has been kind of increasingly eviscerated?
Sure. Well, so just to give you a thumbnail sketch, after the Civil War, if we're going to go back that far, Congress passed what are known as the Reconstruction Amendments, the 13th Amendment ending slavery, the 14th Amendment providing a lot of things, including equal protection and due process protection from the states, and the 15th Amendment, which bars racial discrimination in voting. Even though the 15th Amendment says you can't discriminate on the basis of race, and even though right after that amendment there was significant Black male voting in southern states, by the end of the 19th century, there came a period called the Redemption when basically there was complete voter suppression of Black voting in the United States. And the Supreme Court refused to intervene, and it wasn't until Congress passes the 1965 Voting Rights Act that we start getting significant Black protection in all of the United States. So just to take one example, in Mississippi, 6.7% of Black voters were registered to vote in 1964, and that number goes above 50% in 1968. So a big difference to start. And one of the key parts of the Voting Rights Act back in 65 was a part that said that states with a history of discrimination, mostly in the South, had to get federal approval before they could make changes in their voting rules. That was the pre-clearance provisions. This really helped to increase minority voter registration, but it didn't do enough to help with minority representation in Congress, because we'd have situations where Blacks and whites would vote for different candidates, and under the election rules where, say, everyone in the city is voting for everyone on the city council, called at-large voting, the white preferred candidates would always win. And so there were challenges to these kinds of systems under the 15th Amendment. The Supreme Court said, you need to show intentional discrimination. That led to the significant 1982 amendments to the Voting Rights Act, which are at issue in the Supreme Court's case that it's hearing now, Louisiana versus Callais. That provision says that across the country, not just in these targeted places, that minority voters should have the same opportunities as others to participate in the political process and to elect representatives of their choice. And that's led to the creation of districts, minority opportunity districts, where Black, Latino, Native American, Asian voters have a chance, as districts are drawn, to elect their preferred candidates. Supreme Court repeatedly upheld the constitutionality of the Voting Rights Act, but then things started to change. In 2013, the Supreme Court, in a case called Shelby County versus Holder, killed off that preclearance provision, saying time was up. These states, you have to show more recent history of intentional discrimination to justify such a law. And then the court, through statutory interpretation, has been weakening Section 2 in various contexts. And the case that comes to the Supreme Court in Louisiana versus Callais arises out of some redistricting in the state of Louisiana for congressional districts, and it raises the question about whether the race-conscious districting that Section 2 requires, which the court had said in the past was constitutional and was workable as a way of remedying past discrimination, is no longer constitutional or is going to have to be further weakened.
So can you just talk a little bit, Rick, about the practical impact that a ruling could have? So in other words, I think a lot of our viewers and listeners are going to want to understand, what is this going to mean if, for example, hypothetically, the Supreme Court did further weaken or roll back Section 2?
So Louisiana is a good example. So Louisiana has 8 congressional districts. There was, after the latest census and latest round of redistricting at the beginning of the 2020s, there was a plan that was drawn that created one Black Opportunity District. Black voters make up about a third of Louisiana. So there was a lawsuit brought before Louisiana versus Callais, which basically said, there really needs to be a second district where minority voters can have a chance to elect their candidates. White and Black voters in the state prefer different candidates. There are lots of Black voters who live in a concentrated area. You could draw another district, and you should. Louisiana first fought back against that and then said, okay, we're going to do it. And then they were sued by another group of voters, a group of white voters who said, hey, you're making race too important in drawing districts. That violates the Equal Protection Clause. That's what's at issue in Louisiana versus Callais. It started off last year as a case where the question was whether race or party predominated in drawing the lines, because to show an equal protection violation, you have to show that race predominated. The court's heard a lot of cases like this. It's a really weird question to ask in the South, where most Blacks prefer the Democratic Party and most whites prefer the Republican Party, but such as it is, that's what the court looked like it was going to do. But then at the end of the term, the Supreme Court decided, you know what, we need to have more argument. We'll tell you what we want to talk about later. And then in the middle of the summer, August 1st, on a Friday afternoon after 5 o'clock, the court put out its new question, which is basically, is the Voting Rights Act, which is supposedly justifying the drawing of this line, is it itself unconstitutional? So that really raised the stakes in the case. And so if the court says the voting Section 2 is no longer constitutional, or if the court reads Section 2 so that it would no longer require the drawing of a second Black Opportunity District in Louisiana, that could mean across the country, in those jurisdictions that drew these kinds of districts to favor minority voters, to give them a fair shot at electing their candidates of their choice, that these districts could be redrawn. We're already in a period of redistricting. There could be redistricting. One estimate says there could be 19 House seats that are held by minority preferred candidates who might be gerrymandered out of their seats. But it also would have implications for state elections, because these rules apply to state legislatures, and also for local elections, city councils, boards of supervisors, and all kinds of bodies. Wherever there are places where there's a significant minority population and there's racially polarized voting, then it's possible, although not guaranteed, you could try to bring one of these Section 2 lawsuits.
So just for our listeners, because many of them are not lawyers, the piece that you said about the Supreme Court framing the question, people might not realize that the Supreme Court gets to frame the question, right? Things can go up on appeal, but they can actually decide what is a specific question to be briefed. And I mean, it's pretty unusual also to squarely present a constitutional question, right? Because I mean, the canon of jurisprudence is to avoid the constitutional questions if you can. So isn't that a tell right there? And how do they come to an agreement on the question presented? In other words, do they need a majority of people to agree on which question to present? And is that itself a harbinger of kind of where they want to go with it?
So in a typical normal case, not one of those shadow docket cases that I'm sure you've been talking about on other episodes, someone will file what's called a cert petition for writ of certiorari, and they will list a question or questions presented. And typically those are the questions that the court agrees to hear. Occasionally the court will reframe the question because they want to focus on one thing. Sometimes they'll say, well, it'll address question 1, but not question 2, because they don't want to agree. And they vote on those things and they decide. So what likely happened after the oral argument last March in the Callais case is that there was some tentative vote. And I think what happened is, under this equal protection analysis, there's two stages. One, does race or party predominate? And then only if race predominates, do you get to the question, is there a compelling reason to make race predominate? And the compelling reason that would be offered is to comply with Section 2 of the Voting Rights Act. So what I'm guessing, I have no inside information, what I'm guessing happened is there was a majority of justices who were going to say race predominated, not party, which made them address the second question. Now, the court has addressed that second question before. And when they've said this a racial gerrymander, that race predominated, and someone said, hey, the Voting Rights Act made me do it. In every case, the Supreme Court said, actually, the Voting Rights Act doesn't require you to do it. That's a kind of an example of constitutional avoidance. Like, we don't have to decide if the Voting Rights Act is a compelling reason if it doesn't make you do it. And that could happen here, too. So constitutional avoidance could actually work to eviscerate the Voting Rights Act without striking it down, say, oh, if the Voting Rights Act were read in the way that the plaintiffs want, well, that would be unconstitutional. We have to read it in a new way. Now, to do that, they'd have to overturn 40 years of precedents, because back in 1986, the first time the Supreme Court addressed what the new language in Section 2 from the 1982 amendments meant, a case called Thornburg versus Jingles, the court said, here's what it means. And they put out a 3-part threshold test followed by an 11-factor we don't need to get into it, multi-factor totality of the circumstances test. The court and the U.S. Department of Justice, the Trump Justice Department, saying, hey, why don't you throw out that case? And you don't have to kill the whole Voting Rights Act, but rewrite the Voting Rights Act, our understanding of it, in a new way, a way that would basically mean that plaintiffs would almost always lose. This is actually, I think, something that could be attractive to the conservative justices who might otherwise want to strike down the act, because, hey, if they strike down Section 2 of the act after they struck down Section 5 in Shelby County in the 2013 case, it's going to be a really big deal. But if they issue some technical mumbo jumbo, we no longer apply the 3-part test, we're going to have this new 5-part test, but it's a test that nobody can meet, then it will get a lot less attention, but it will be almost as deadly. And there's a pathway for this to happen. So back in 2021, the Supreme Court for the first time addressed, what does Section 2 mean outside the context of redistricting? In this case, in the context of a law that says that people who cast their ballots in the wrong precinct shouldn't have their votes counted. There was a racially discriminatory effect of this law. And there's also a law about not collecting absentee ballots from voters. And the Supreme Court, in an opinion by Justice Alito, the case called Brnovich versus Democratic National Committee, the Supreme Court came up with a new test for how Section 2 should apply outside the context of redistricting. And that test, I said it at the time, and I got a lot of pushback. I said, that test is going to be impossible for plaintiffs to meet. And some voting rights lawyer says, no, we're going to try. We'll do it. Okay, so now we're about 5 years later. There has not been a single successful Section 2 lawsuit outside of redistricting since the Brnovich case. And so that means Section 2 is still on the books, but it has no purchase. It has no value outside of the redistricting context. I'm worried we're going to see the same Alito treatment that we saw in Brnovich being applied in the Callais case as to redistricting.
So one thing, Rick, for a lot of our listeners, they've been hearing a lot about redistricting this year anyway, right? Even outside of this context, because there's been a lot of redistricting that's been done in between usual redistricting periods, pushed by by Trump to essentially gain Republican districts. And this is in many ways, I believe, although you can correct me if I'm wrong, in many ways a result of Supreme Court rulings which have essentially put no constraints on political gerrymandering whatsoever. I think it would be helpful for our listeners to understand that context, because I think that raises the stakes for this, right? Because it essentially means that there's really almost no bounds whatsoever on redistrictors if we end up with a Section 2 standard that you suggest might occur.
Right. So every state has to redraw the congressional districts to assure equal populations in the districts after each census. And so the Supreme Court in cases from the 1960s say 1 person, 1 vote. You have to draw these districts with equal populations. So when that is done, you have to comply with 1 person, 1 vote. There's lots of ways to draw the districts to help one political party or another. And the Supreme Court, for a couple of decades, kind of left the door open to possibly this violates the Equal Protection Clause when you make partisanship so important when you draw really disproportionate districts. And the Supreme Court, in a case called Rucho versus Common Cause in 2019, said federal courts are not open to these claims. It might be unconstitutional, but we have no standards to judge when partisanship goes too far. And so we're out of this business. Now, some states still police gerrymandering under their state constitution. So that provides a kind of limit. But as a federal matter, the only limits now are you have to draw equal districts. You have to comply with Section 2 of the Voting Rights Act, and you can't be a racial gerrymander. You can't make race the predominant factor. So in 2021, Texas drew congressional districts, which Black and Latino plaintiffs claimed were actually a violation of Section 2 of the Voting Rights Act and were racial gerrymanders. There's an ongoing lawsuit over those 2021 lines. And now, thanks to Donald Trump pressuring Texas to go even further, Texas redistricted. They drew the lines again in the middle of the decade. As you said, it's rare. It's not unprecedented. Texas did it in 2006, but it's rare. And now those new lines are being challenged by the same plaintiffs in the same lawsuit saying, hey, this violates Section 2. It's a racial gerrymander. And so there's all of these redistrictings going on. California is potentially going to do a Democratic gerrymander if voters pass what's known as Proposition 50 on November 4th. Which would kind of overtake the existing lines for the rest of the decade for congressional districts. And so when these things are challenged, as the redistricting happens, if Section 2 is gone, well, then that might be an occasion for Texas to draw the lines yet again. And it means that the kind of Section 2 challenges that are being brought now would be unsuccessful, or they'd be judged under a new, weaker standard. And it would be much less likely that you would draw districts to give minority voters a fair chance to elect their candidates of their choice. Now, there's still, under the 15th Amendment, there's still precedent saying you can't intentionally discriminate against minority voters. That would be a violation of the Equal Protection Clause. You can have a discriminatory effect under the 15th Amendment, but you can't have discriminatory intent. So Justice Alito seemed to have an answer to this at the oral argument in Callais. Oh, well, they're not discriminating against those voters of color because of their race or ethnicity. They're discriminating against them because they're Democrats. So partisan gerrymandering becomes kind of the safe harbor. Hey, we did it because of this. And so just this week, North Carolina is like a 50-50 state. There's about equal numbers of Democrats and Republicans. It has a 14-member congressional district, a fair distribution, which at one point North Carolina had because they had a state Supreme Court that said partisan gerrymandering violates the state constitution. 7-7 split, 7 Democratic likely districts, 7 Republican likely districts. After the 2021 redistricting, it went to 10 Republican districts. Now it's going to 11. They've redistricted. And in North Carolina, even though it has a Democratic governor, their redistricting plans don't get governor's approval. It just comes out of the state's legislature called the General Assembly. So now there'll be a challenge eliminating this black opportunity district. There's going to be a challenge arguing that redistricting violates Section 2. If Section 2 is gone, that challenge will fail. So we'll see.
So I'm sorry, I just want to rewind so I understand like what the Section 2 issue is. So race can't predominate. But Section 2 is there to prevent racial dilution.
Right. So
in other words, I'm wondering how you extricate those then. Do you know what I'm saying? Or is that the issue?
So you can be race conscious under Section 2, but race can't be the most important factor. Now, states like Louisiana have always complained about this and said, well, you've got us between the rock and a hard place. Like, how can we comply with both of these? And the plaintiffs in these cases have said, well, it's really easy. Draw nice-looking compact districts where Black or Latino or Native or Asian voters can elect their candidates of their choice. And there's lots of ways you can draw those lines. Race doesn't have to predominate in doing it, but you're race conscious, making sure that there's a chance to do this. Now, some of the justices say that very race consciousness is unconstitutional. You can't do that at all. That's a step further than where the current law is. That would be ironic, ahistorical, and repugnant. The reason I say this is the justice who'd say you can't be race conscious would be relying on the Equal Protection Clause. Well, the Equal Protection Clause in the 14th Amendment and the 15th Amendment bar on racial discrimination voting were passed by the Reconstruction Congress in order to protect Black voters. In the period right after these amendments passed, Congress passed race-conscious legislation protecting former slaves. So if you're an originalist and you're going to look at the Equal Protection Clause, what it means, how it was understood at the time by those who were around, you'd say, oh, race consciousness, that's okay. Sure, you can't make race predominant. It can't be the most important thing. So there's a way to square these two things. Some of the justices who are opposed to a strong Section 2 of the Voting Rights Act saying, well, race consciousness kind of moves us up to the line, so we're going to water down Section 2, so it's not that race conscious. So it's less race conscious. And, if you actually look at the facts in the Callais case, in that earlier litigation, the federal court said, Louisiana probably is violating the Voting Rights Act if it doesn't create a second Black opportunity district. Where the state of Louisiana put that district was not in the most natural place to draw a nice, compact, beautiful-looking Black opportunity district. They drew the really contorted district. Why? They were trying to help Mike Johnson and make sure he, the Speaker of the House, would have an easy time getting reelected. So, partisanship predominated in how those lines were drawn. Race consciousness meant there had to be another district where Black voters could elect their candidate of choice. But how it was done was very political. So there are ways to reconcile these two things. It's a question of whether the court wants to do it. And I'll make one more point, which is that Justice Kavanaugh, who in a 2022 Alabama case said he'd go along with the majority and uphold a very similar case, the requirement that Alabama draw a second Black opportunity district for Congress. Kavanaugh in that case concurred, and he said, nobody in this case really made the argument that time's up for Section 2 of the Voting Rights Act the way they've said time's up for Section 5 in the Shelby County case. I'd like to hear that in a future case. So now that, of course, is front and center. And Louisiana and other states are arguing, hey, time's up. And the response of the plaintiffs to that has been, no, Section 2 is very different than Section 5. Section 2 self-sunsets. When there's no more racially polarized voting, when whites and minority voters prefer overlapping sets of candidates, then you can't make out a Section 2 violation. As our society becomes more colorblind, Section 2 becomes less necessary. We'll see if that argument carries the day.
The time's up piece also surfaced in the affirmative action case. So they definitely seem like they are, that is sort of their, and that's how they would square this originalist argument, right? Like, yes, Congress passed race conscious legislation immediately after the Reconstruction Amendments because it was Reconstruction. And now it's 2025 and we're post-racial or whatever they claim, because some of those same arguments were coming up in that affirmative action case. Like, this will never end, basically, was their argument. If we allow this to continue, there's just no end in sight.
Justice Kavanaugh said exactly that in the oral argument in the Callais case. He said, why isn't 25 years like there should be a time limit? Right, so he's definitely thinking along those lines. Of course, there's nothing in the Constitution that imposes a time limit. What's in the Constitution? In Section 2 of the 15th Amendment and in Section 5 of the 14th Amendment, it says Congress shall have the power to enforce this amendment by appropriate legislation. That is, this is a judgment call that the Constitution textually commits to Congress, not to the court to make this decision. But the court, very full of itself, thinking it has to have the last word on all of these questions, decided to second guess. It said time was up in the Section 5 context. And in that Shelby County case, they said, don't worry, if we get rid of Section 5, it'll be fine because there's still Section 2 and it applies nationwide and it doesn't expire. So don't worry. Now, of course, they put Section 2 on the chopping block. So, it's a little bit of a bait and switch.
Earlier you talked about how, for example, in North Carolina, the state legislature ultimately determines redistricting. It's the case in many states, and although, of course, as you suggested, the governor has a role in certain of those states. What I find interesting is, of course, state legislatures also draw the districts for state legislators. And so, can you talk a little bit about the impact that this could have downstream as well on all sorts of other races?
Sure. And so there's lots of Section 2 litigation that involves state legislatures or local jurisdictions. In fact, this is a huge problem. So in North Dakota, for example, Native voters getting their candidates of choice, that has proven to be, in the state legislature, that has proven to be a very difficult question. And these cases are expensive to litigate. They require lots of expert testimony about patterns of voting in elections. And I should tell you, there's another case that is pending before the Supreme Court. The court may or may not take it. This is a case, Turtle Mountain Band of Chippewa Indians versus Howe. In that case, the Eighth Circuit said, you know what, we read Section 2 as not giving private plaintiffs the right to sue to enforce it. Only the United States Department of Justice has the right to sue to enforce it. This idea that Section 2 confers no private right of action, and that 42 U.S.C. Section 1983, which allows for suits for deprivation of constitutional rights, also doesn't allow for a private right of action. This is also ahistorical, atextual, very much against what Congress obviously knew, since well over 90% of Section 2 cases have been brought by private plaintiffs rather than brought by the United States government. The Trump Justice Department has brought 0 Section 2 cases. I believe it brought 0 Section 2 cases during the first Trump administration. So this is another way that Section 2 could be essentially killed off without declaring it unconstitutional. We'll see if the court takes that case. Maybe they'll hold that case until they resolve the Louisiana case. I don't know. But that is yet another threat. And it means, what affects people's lives from day to day, sure, what the federal government does has a big effect. But lots of times it's what's happening in my city council, or what's happening at the county level, what's happening in the state legislature. There's a lot of decisions that are made that really affect people's lives. Decisions about water, about education, about transportation and infrastructure, about what projects are going to be funded. These are all state matters. And minority voters stand to lose representations in these bodies too. And so I'm afraid that we're going to see a bleaching of legislative bodies across the United States if, in fact, the Supreme Court significantly weakens or strikes down Section 2.
That's really the point about narrowing. I guess it was a standing issue, right? Of only conferring standing on the Department of Justice to bring these kinds of claims.
Well, it's not quite standing. The issue is whether or not is any statute that that Congress passes. There's the question of who can enforce it.
Who has the right of action to...
Yeah, who can enforce it? Does it have a private right of action? Sometimes Congress explicitly says, private parties can sue. Lots of times it doesn't. The court has gotten much stingier in terms of when they recognize a private right to sue. But when Congress amended the Voting Rights Act in 2006, they knew full well that 90% plus of the cases that were brought under Section 2 were brought by private plaintiffs. And Congress didn't say, oh, no, we don't want that. They kept that part in there. They changed other things that the Supreme Court had said in terms of interpreting what Section 2 means that they didn't like. But Congress did not change that at all. So the idea that Congress wouldn't have conferred a private right of action is just belied by history. Even the Fifth Circuit, which is arguably the most conservative circuit in the country, said, yes, there's a private right of action. Plaintiffs can sue. And then they said, but they'll probably lose for these reasons. But at least they said they could sue.
One thing that I think is important for everyone to understand here, I think people think we talk a lot about democracy, and that's a word that's evoked a lot in in the recent No Kings protests and so forth. But when I asked you earlier about the state representatives, of course, there's this issue of entrenching, right? Where essentially, no matter how public opinion sways regarding candidates, if ultimately districts can be drawn in such a way where it's very challenging, right, for the opinion of the populace to effectively change the composition, whether it's Congress or state legislators that could potentially draw districts for Congress, how thick is the concept of democracy in the Constitution? If you can help our listeners understand actually how that works in our constitutional structure, I think that would be helpful.
Well, the Constitution contains no affirmative right to vote. Even as to the House of Representatives, which was the only federal body where there was elected. Now, presidents were chosen by state legislatures, senators were chosen by state legislatures, but as to who could vote for members of the House of Representatives, it said, well, whoever the state lets vote for the state legislature, that's who can vote for Congress. And then when you think about the Constitution being expanded to protect the right to vote, all of those expansions are framed in the negative. If you're going to hold an election, don't discriminate on the basis of race. If you're going to hold an election, don't discriminate on the basis of sex. That's the 19th Amendment. We don't have an affirmative right to vote in the Constitution. That's why I wrote my book, A Real Right to Vote, which argues that we need to do it. We can't trust the courts. The courts have been around for 235 years. There's only about a 1-decade period during the period of the Warren Court when the court was leading on voting rights. Lots of times the court has been either neutral or a foe to strong voting rights, in part because the Constitution is such a weak document. It's so old. It was written at a time when there were property restrictions on voting, gender restrictions on voting, racial restrictions on voting. And so we shouldn't be surprised that the document is not adequate for a 21st century multiracial democracy. The Constitution needs to be amended to give a real right to vote in it so that people don't have to keep fighting over these basic things. And on the question of gerrymandering, you're right that it was the Supreme Court that had to step in the 1960s when districts were drawn when they didn't even have equal numbers of people. So rural areas were way overrepresented in state legislative districts. That's when the Supreme Court started imposing these one person, one vote rules. I worried that those too could be on the chopping block before the Supreme Court. So how bad it could get for our democracy in front of the Supreme Court, we may not be hitting the bottom, even if we get a bad result in the Callais case.
Well, I don't want you to leave on that note. Because I feel like our podcasts always end with people wanting to jump out a window. So can you maybe just maybe as a up note, what can be done? Are there additional, if the Constitution isn't an effective bulwark, I mean, it is a floor, it's not the ceiling, right? Is there any way are there models that we can follow from states that might be shoring up these rights, either in rules for redistricting or protecting voting rights or anything like that?
Let me draw a lesson from history. In 1874, the Supreme Court decided a case called Minor versus Happersett, which was about a woman from Missouri. She said, look, I'm a citizen, I'm white. I should be allowed to vote in a federal election. And it's one of the privileges or immunities of citizenship protected by the 14th Amendment. And the Supreme Court said, yeah, you're a citizen, but whether or not you can vote, that's up to the states. And so the state can decide men only get to vote. And after that happened, it took 40 more years of organizing before the passage of the 19th Amendment, which barred discrimination in voting on the basis of sex. Along the way, over 30 states amended their state constitutions to bar discrimination in voting on the basis of gender. And so it was a political movement. And as I wrote recently in a piece about the Callais case that appeared on the MSNBC website, I'm hopeful that this new era that we're going into, where the courts are reading our voting rights out of the Constitution, will spur a new civil rights movement. It's going to take the people. We're going to need, when we get past the current moment, we're going to need to rethink, how can we strengthen our Constitution? It's going to take a popular movement. I mean, think back to the 1960s. We amended the Constitution a number of times and strengthened voting rights. Now, in 1971, 26th Amendment, no discrimination voting against 18 to 21-year-olds. It's time, right? We lost our muscle memory when it comes to how to pass a constitutional amendment. So we really have to think about that as a way forward, because the courts are not going to save us right now in our democracy.
Thank you, Rick. Oh, go ahead, Renato.
I was going to say the same. Thank you so much, Professor. It was fantastic.
It was great talking to you. Maybe we could talk about something more cheerful next time.
We'll have you back. Thanks a lot.
Bye-bye.
So, Asha, We in any other week this would have been perhaps the number one story, and that's the indictment of the former National Security Advisor John Bolton. Obviously, yet another critic of Trump, adversary of Trump, being indicted. Although this one seems like it has a lot more meat to the bones than some of the other indictments we've seen recently.
Yeah, so I think this will be an interesting conversation because you and I actually haven't discussed this before getting on our pod today. So listeners are going to really listen to us unpack it together. And I'm curious whether we disagree on that point. That was my takeaway, that we've talked about the Comey indictment and how flimsy it is. We've talked about the Letitia James indictment and how flimsy it is. This does not seem particularly flimsy to me. In fact, this seems like, when we look at the claim of selective prosecution, where similarly situated people, have not been prosecuted or would not be prosecuted for similar behavior or actions, that doesn't apply here. I mean, for what is described in this indictment, I think anyone would have been investigated for sure and likely charged. And the fact that it's a former national security advisor, I think only makes it worse.
The only thing that could have made it worse is if he actually removed documents and then kept them in his bathroom or ballroom or something like that. But in all seriousness, no, I genuinely agree with that. What I would say is that the Comey indictment, the Letitia James indictment, are questionable on their face. Now, we don't know all the evidence and so forth. Okay, we only know what we know right now, right? We have limited public information, but just looking at the four corners of them, there are questions. You can draw questions. This one, that's not the case. Now, I will say that in the space of national security indictments, there are judgment calls that are made regarding whether or not you indict certain persons. And this is something that, for example, was an issue around the Clinton investigation, when that was ongoing before Trump's first election, whether or not that was, for example, the sort of case that would have been prosecuted. Comey famously talked about that to Congress. It's interesting. I mean, there's been reporting that this case was ongoing there was an investigation ongoing during the Biden administration, and during that DOJ, they didn't prosecute. Is that your understanding as well, Asha?
Yeah, so why don't we unpack the indictment and kind of go through the timeline? Because I think that is an important piece of it, and I think it's an important difference from the other charges that we've seen. I mean, look, just in the length alone, in our previous podcast, you can go back and see the actual charging documents for Comey and James that were like, 2 or 3 pages each? I think 2, just a few paragraphs with some very vague allegations, or even misleading allegations in the case of Comey. But this is a 26-page indictment, and this goes back to his actions, starting from 2018, when he becomes the national security advisor in the first Trump administration. And you just have paragraph after paragraph, just so we describe what he was allegedly doing, according to this indictment, is that on a pretty regular basis, perhaps like almost daily, he would kind of take the things that happened that day and essentially, it looks like, come home and type it up and then send documents of those notes from what happened that day to people that are referred to as individual 1 and individual 2 in the indictment, but which we understand to be his wife and his daughter. And this is what they're calling it, his diary. But Renato, let me be clear. If I go into a skiff, for example, and I read a document that says, so-and-so is a Russian source for the CIA. And I read this document in the skiff. I leave the document there. And I come out and I come home and I literally type into a Word document what I read in the skiff. My Word document then has classified information, even if I did not physically remove the document from the skiff. And I can't say, well, that's my diary and I'm just writing down. I mean, I find it weird that they have claimed that that was just a diary.
Well, that's the defense argument on it. I would say that there's no question that Bolton exercised extraordinarily poor judgment here. And if the allegations in the indictment are true, it sure looks like he violated the Espionage Act. Okay. So I think it sure looks that way. I think the real question, and that's why I think this is very different in certain respects than these other cases that are a little bit more sketch, to use an Asha term, a little sketchy, some of the other cases. But I think there's another question is this a sort of thing that should be prosecuted criminally? And is this the appropriate case for prosecution? And one thing I found interesting about it, Asha, is regarding his mental state. In the indictment, they included media interviews of John Bolton, in which, one, he criticizes Hillary Clinton and her use of a private email server, and two, one in which he criticizes Trump administration officials for using Signal, because, of course, he used Signal to communicate with his wife and daughter.
Yes.
Yeah. I mean, it's interesting, right? His own commentary, in many ways, is going to show his state of mind and his own understanding of his obligations regarding the handling of classified material.
Well, and the way that this information appears to have been discovered essentially manifests the very risk that we're afraid of when people take home classified information. So in the Hillary Clinton example, she was communicating with people in her, who work with her on this private server. As far as I'm aware, she was not like coming back and typing up like notes of like classified things. The emails were later determined to have within them some things that, maybe I can't remember if at the time or later were classified. But the risk that was claimed that warranted her investigation was that by virtue of being on a private server, it could be hacked. And if there's classified information, because it's not secure, and that information got into the hands of adversaries, this could present a national security threat. Well, lo and behold, John Bolton got hacked, apparently by Iran. And Iran got a hold of all of these diaries, quote unquote, that he was sending to his wife and daughter. And again, just to kind of make this clear, I mean, the paragraphs include like, on one day he sends a 24-page document. On another day he sends a 77-page document. On another day he sends a 50-page document. So these are, lengthy notes with great amounts of detail. Apparently he's hacked by a foreign adversary. We learn to be, yes, it says that it's Iran. Then the hackers write to him and say, I don't think you'd be interested in the FBI being aware of, what we've, basically what we have. It'll be the biggest thing since the leak of Hillary Clinton's documents. Now, Bolton reports the fact that he's been hacked to the FBI, but it's not clear to me that he let them know at the time that he had this information that he had these things on his computer. Which again, I think is sketch number 2, right? Like, so he's going into these classified briefings and meetings. He's coming back, he's typing them up and he's sending them to his wife and daughter. Already sketch. Then he gets hacked and then he calls the FBI, but he doesn't alert them. It doesn't seem like to me that there could be major compromising national security information that has been obtained. But this is the very risk that we are worried about when people are talking on Signal chats or storing documents in their bathroom or on private servers. So to me, that is something also that makes a difference.
Yeah, it's interesting. I read that differently about the communication to the FBI, but I think reasonable minds can differ there. I think another thing that is interesting about this, right, is he ultimately writes a book that is based in part or in large part on these quote unquote diaries. And my recollection is he did not get pre-publication authorization regarding that book. And, in other words, usually you go and you get you send a copy to the book, and, to the relevant officials who actually look at that and determine, hey, you should edit this line or that line has some secret in it. My recollection is he did not have that authorization at the time. Is that also your understanding, Asha?
So I wrote a long cafe note, which I published in my Substack about this. So he did not. So what happened with his book is that these diaries, he pretty much collated together and created a manuscript. And then he submitted it for pre-publication review. And the National Security Council has its own pre-publication review section that has a career person who does this, who looked at the manuscript and said, whoa, 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 Tiger, there's a lot of classified information here. You've got to clean this up. And so they spent several months going back and forth where he takes out stuff, he cleans up, whatever. He sanitizes it to a point where the career person said, okay, this is, at a place where it could be published. Let me get basically the final sign off. And what happens at that point, Renato, is that Michael Ellis, who we have talked about before, I call him Where's Waldo because he shows up in different places. He happened to be at the National Security Council then, and he inserted himself into this pre-publication review and essentially decided to redo the pre-publication review and went through, and I don't know if he then decided, he was an original classification authority, which meant that he could classify things. I don't know if he reclassified things or he just suddenly decided that there were things that were classified. Anyway, the final sign off never comes. Okay, even though Bolton had gone through the whole thing and he chose to go ahead and publish it anyway, which is what leads to this lawsuit later. And so I think there was an assumption early on that the charges against him were going to be violations of the Espionage Act for publishing the book without clearance, right? But it's not exactly. It's about all of these documents. And I'm curious why you think you thought that he told the FBI this. I mean, he told them that he got hacked and he said, he said there could be sensitive material. I don't know that he made it clear that he had, potentially classified material on there. But also it sounds like this gets to the Biden investigation. The Trump administration starts an investigation on him in addition to the lawsuit, which continues into the Biden administration. It was during the Biden administration where the hack occurs and he calls the FBI. And at some point, I guess they close the case. They also decide to, not proceed with the lawsuit. But part of that was that he agreed to give them anything that he had left, including his the old manuscript that had all this classified information and all the things in his possession. And clearly he didn't, according to the indictment, allegedly.
According to the indictment. So here, the reason that I thought that he had come clean is that the portion where it discusses alerting the FBI, they talk about his representative talking and alerting the FBI. And so the way I read that is he had an attorney handle this for him, understandably, and have those communications with the FBI. And then the indictment wouldn't include all the back and forth or get into too much details about the scope of the conversations between this quote unquote representative, who I think would, my reading of that is that that's likely an attorney, had with the, without Bolton being part of those conversations with the FBI, because that would really be far afield. But that statement was included there, essentially to remove the sting of that paragraph, because otherwise, if they just said, "Hey, the Iranians hacked," and they didn't acknowledge that he promptly informed the FBI, then potentially the defense could try to get that paragraph redacted and say that it would be too prejudicial or something, like it's irrelevant to the charges, etc. So that's what I thought on it, but I could be wrong. But I think I want to just focus here on for a minute, on the Biden administration's decision, Asha. Because the Biden administration looked at I think roughly the same facts. Maybe more was found out later. Okay, you don't think it's the same facts. So, all right. Well, why do you think it's not the same facts? Because they found out later they didn't give him everything. Is that why?
Because it sounds like Iran hacked him, got copies of all of these diaries. When Bolton, from what I understand, when I'm reading the indictment, when Bolton reported the FBI hack, he did not hand over these diaries and said, "Hey, this is what the Iranians appear to have." Okay. I don't think the FBI knew. If they did know, then I think there's a bigger question on why this was not pursued further by the Biden administration, because it's pretty serious. But I think the one sketchy thing is somehow what was in Iran's possession made its way to the FBI via the CIA under Trump too this year, which is what leads to the search on his home. That to me is a puzzling part. It could be that, I mean, Iran has an assassination plot on I think they've tried twice right now to assassinate Bolton. So they hate this guy. They may very well have just dumped all these things in the CIA's lap and said, "Hey, this guy has classified information." And then they're very happy to see him go to jail. But it is really interesting to me that somehow the contents of this hack suddenly make its way to our intelligence community now. If they were already in the possession of our intelligence community in the Biden administration, I think that raises a different question on why this case was not pursued more aggressively.
Well, that was my question. So that was my reading of the situation, was that the Biden administration either decided they didn't want to prosecute a former Trump official here in this context, and they decided they didn't want to do this for whatever reason. And the Biden administration was not exactly hyper aggressive when it came to criminal prosecution, particularly ones that could be seen as political in any way. So I thought that might have been the case. But it's if ultimately the Trump administration, Trump 2 administration got more information, then that might explain it. But I do think that regardless, I mean, the bottom line from both of us is that this appears to be a prosecution that is not questionable on its face, to put it mildly.
It's not questionable on its face to me. There is a very detailed log of the various documents that were recovered and the kind of information that's in there and the classification level that kind of information would have. And also, this indictment is signed by several prosecutors from the National Security Division, the acting chief, the counterintelligence from the Counterintelligence and Export Control Center, the acting deputy chief, the attorney from the National Security Cyber Section. I mean, there's a number of people, because as we've noted in the Comey and the Letitia James indictment, that was only Lindsay Halligan, remember, who presented those indictments and signed those documents because she couldn't find another prosecutor to do it. So this tells me that also there were career prosecutors who were willing to put their names to this. And I think that means something still.
Yeah, I agree with that. I agree with that. So I think there's still a lot more to learn about the facts here. I think there's more than meets the eye here one way or another. I mean, the fact that you and I are interpreting certain things in here differently, to me, just means that there's still more. I think that we don't know everything that we would like to know about this. More will come. I think it's fair to say that I personally am keeping an open mind about some of these things. I want to see kind of how this all plays out. But this is one that I would put in a different bucket than the recent indictments that we've been talking a lot about.
Yeah, I would agree. I would put this in the trust but verify bucket, which does not have many documents in it at this point. But you know what I mean? That the length of time that this has gone on, that it did span, that the investigation into this spanned 2 different administrations, that it is signed off by career attorneys, the level of detail that's in the indictment itself, the nature of the charges and what is being alleged is quite serious. So I think all of these things should merit some scrutiny. And I think it just gets to, unfortunately, we are in a situation now where we've talked about before, the presumption of regularity doesn't necessarily apply. However, I think that it is a rebuttable presumption of irregularity. You know what I mean? In other words, I don't think necessarily we're at a point where literally everything that's coming out is, suspect. But I think what makes this worrisome is just that Bolton is one of Trump's enemies, and I think it's unfortunate that we are now in a place where we have to parse these things so carefully because it's not really clear. We can't trust that they are valid on their face.
I think that's right. I also think that there's been a lot of discussion and debate about where the prosecutable line is related to the handling of classified material. A, B. We also have, as I kind of alluded to early on, if anyone didn't catch that, Trump, of course, had his own transportation, handling, of classified material, transfer of classified material to third parties, et cetera, that never got resolved. There's presidential immunity there. I mean, perhaps Bolton's best argument might be Trump told me to do this. I was ordered by the president to do this. What do you do with that? But in all seriousness, it's really something that we live in a world in which we have a president who literally took boxes and boxes of classified material, hid it in his bathroom and ballroom, totally unprosecutable. But we have somebody who took a fraction of that and is being prosecuted by the Justice Department of that same president.
And not just Trump. I mean, we have cabinet officials who had discussions on Signal on very sensitive national security related things, the kinds of things that these documents apparently contain, like war plans and, contingencies in the event of military strikes and things like that. And again, Secretary Hegseth and Tulsi Gabbard and JD, like all these people who were involved in that wasn't even investigated by the Department of Justice. They just dropped that and said, oh yeah, that didn't compromise national security. So yes, I agree with you that, whatever comes of the Bolton case, that it only underscores, I think, the righteousness and the seriousness of the classified documents case that was brought by Jack Smith.
Yeah, absolutely. The fact that the Signal, that Bolton's commentary regarding this Signal chat is cited in here, but yet there's been no investigation of the facts underlying that itself is quite telling. So, Asha, we've been talking a lot about our cruise and traveling to Alaska. Obviously, link below if you're interested in coming with Asha and I on a cruise to Alaska. But I think you've been traveling. You just were traveling somewhere else recently.
Yes, to a different cruise stop, actually.
No kidding.
Yeah, there are North American cruises that go to Canada and stop in Halifax, which is where I was. I was there. So Halifax is the home of Dalhousie University, and they have something every year called the Stanfield Conversations, which are, bring in scholars, journalists, practitioners, depending on the year, to talk about issues facing democracy. And this year it was challenges to the rule of law. So I was on a panel with a law professor from Dalhousie Law School. And it was moderated by a CBC anchor, Canadian Broadcast Corporation anchor. And it was a great conversation. And all I can say is the Canadians are really worried about us.
Well, they have, yeah, good reason to be. I mean, you literally have president who's talking about annexing Canada, and annexing Greenland, right?
Yeah.
Neighboring country.
Well, and I think it was a very interesting conversation because, somebody said in one of the comments or questions, when America sneezes, Canada catches a cold. And I think there was one of the running questions was, could this happen there? Like, could what's happening here happen there? And I think one of the big takeaways is, to never be complacent. I mean, come on, Renato, if somebody had asked you 10 years ago, if you could go back to Renato from 2015 and you could say 10 years from now, there's going to be a wrecking ball being taken to the White House and there's going to be military in the streets and we're going to be threatening to invade Canada. I mean, 2015, you would have been like, you crazy. And I think it just gets to like how quickly democratic erosion can go. And it was very educational for me because it sounds like there are little rumblings of things, that we were seeing back in 2015, 2016, 2017, surfacing now there.
That's interesting. I thought a parliamentary system might make that more difficult. But I do think, Canada is a beautiful country, very diverse country in terms of, geography, architecture, etc. Halifax, very interesting. I've never been to Halifax, very far eastern part of Canada. What was that like, just to be there?
I have to be honest, I did not get to do a lot of sightseeing. There is apparently, I think, a very picturesque fishing village that I had wanted to see, but the weather was not great on the day that I got there, and then I just didn't have a lot of time. But I heard some people talking about, cruise ships coming in and out. So, I mean, it is a stop on some of these North American, Canadian cruises. It was cute, though. The people were incredibly friendly, very engaged, very concerned, very warm, despite the fact that our president is threatening to invade them. They're not holding it against ordinary Americans. And I'm pleased to say that I hadn't, knock on wood, I had smooth travels back to the United States.
Fantastic. Well, thankfully we're doing our Alaskan cruise in July. I think the weather will be a lot better then.
For sure.
Can't get your fill of Legal AF? Me neither. That's why we formed the Legal AF Substack. Every time we mention something in a hot take, whether it's a court filing or a oral argument, come over to the Substack. You'll find the court filing and the oral argument there, including a daily roundup that I do called, wait for it, Morning AF. What else? All the other contributors from Legal AF are there as well. We got some new reporting. We got interviews. We got ad-free versions of the podcast and hot takes. Where? Legal AF on Substack. Come over now to free subscribe.